Welcome everybody, and it's nice to have you back to the online salons, the online sessions with NGI Forward and IoT Council and Elon Tech. This is Magdalena Gailey on behalf of the European Law Observatory New Technologies, replacing for the introduction Rob van Kranenberg from the IoT Council and the NGI Forward team. Only to briefly welcome our guest speakers for today. The topic is extremely important, and our guest speakers even more interesting experts on the field. So, with no further ado, I will give the floor to Kürten Weisenziel. And welcome everybody to the session, and thank you in advance for
Thank you, Magdalena. I think we have lost you. I'll take over from here if that's okay. And again, I want to welcome all of you to today's NGI Forward Salon on Spotlight on Dark Patterns. What can the ePrivacy regulation do? It's great to have you with us today. Today's event is co-hosted by NGI and the Dark Pattern Detection Project, which is funded in turn by the German Ministry of Justice and Consumer Protection. My name is Kürten Weisenziel. I'm the research group leader of the Dark Pattern Detection Project at the German Research Institute for Public Administration. Let me briefly thank Rob Kranenberg of NGI, Loretta Anania of DG Connect, Carsten Berger, and Anton Kamke of our Research Institute for supporting today's event. Two brief things in the beginning. First, the event will be recorded, and you will be able to review the event from tomorrow on, probably at NGI's YouTube channel. And second, you can ask questions in the channel on the right side of the screen for the Q&A session. We have reserved the last 20 minutes for your questions. Let me introduce our today's speakers, our great panelists. First, Peter Eberl is Deputy Head of Unit for Cybersecurity and Digital Privacy Policy at the European Commission's DG Connect. He works on the legislative negotiations of the privacy regulation, the implementation of the Privacy Directive, and the Network and Information Systems Directive, as well as on other cybersecurity and privacy issues. It's great to have you with us here today. Second, Miriam Fernandez is a lawyer and senior digital policy officer with BEUC, the European Consumer Organization. As such, she represents 45 consumer associations from 32 countries. She's also part of the board of Women at Privacy and the board data protection on the ground chair at, and I'm sorry for that one, Virche Universiteit Brussels. Third, Cristiana Santos, assistant professor at the School of Law, Utrecht University, teaching at the Masters of Law and Technology. Currently, she works on the Gdpr privacy directive requirements for consent and lawfulness of dark patterns within the consent banners and subject access requests. Lastly, Christian Drews, a research fellow at the German Research Institute for Public Administration. His research focuses on the law of digitalization. Currently, he works on dark patterns in the context of privacy and data protection law. Again, thank you all for being here with us today. I think the topic of dark patterns is one of the hottest topics in internet and privacy these days. At least once you look at them, you see them everywhere. What exactly they are is a bit less clear. Some might define them as user interfaces with a substantive effect of subverting or impairing user autonomy, decision-making, or choice. Particularly, cookie banners have proven to be a playground for dark patterns in recent years. Today, we want to discuss what the new privacy regulation can and should do about them. To get off a bit better of an understanding what dark patterns are in the cookie context, we have asked Mr. Drews and Professor Santos to give us a brief introduction into their research so we all know what we're talking about. With that, I want to hand the floor to Christian Drews for his short introduction.
Thank you, Kürten. I was muted. I'm sorry. Can everyone see my presentation? Can you hear me? Okay.
Yes.
All right. So I would like to give you a brief overview over the most common types of dark patterns that we encounter in cookie banners. We have all seen this one. Your consent is pre-selected in a checkbox and you have to proactively deselect if you want to refuse. This type has now largely disappeared, presumably as a consequence of the Planet 49 judgment of the Court of Justice, which found that pre-checked boxes do not lead to consent under the Gdpr or the ePrivacy Directive. Another ones are so-called cookie walls. They block the entire screen and you may not proceed to the content of the website unless you engage with the CMP in one way or the other. Then we have a variety of different patterns that we repeatedly see nowadays. What these have in common is that they make it a lot easier to accept in comparison to refuse consent. They do that either due to visibility. Note that the accept or accept all button is usually brighter in color or larger and thus easier to find, or because it takes more effort to refuse because you have to find and go to the settings or options page first. We actually have some numbers to show you how big this misbalance is. Our partners from Heidelberg University made a crawl of 5,000 websites and extracted the types of buttons that you may find on the first layer of a cookie banner. As you can see, the accept all button is by far the most commonly used one, and we barely see a reject all button. Another finding is that the design is almost always unequal, which again supports the suggestion that the design deliberately makes it easier to accept than to refuse. With this example, I would like to show you how different types of dark patterns are actually combined in practice. So here we see Susie, the cookie bouncer. When I first saw this, I thought, this is pretty cool. So Susie will keep out the cookies for me, right? But what she does is in fact the exact opposite. She actually keeps you out of the website unless you interact with the banner, which is a forced action. We then proceed with an interface interference. As you can see, only the accept button is displayed. If you want to refuse, you have to go to the settings page, in which we see another pattern, and this is a pre-selection pattern. Instead of boxes, we have a bar that we can toggle. However, the privacy unfriendly option is already selected by default. There's further a social proof pattern, which is basically a play with emotions. Cookies are displayed as something we all enjoy, whereas when you change the bar to basic, Susie's mood suddenly changes. Then we have some more patterns, which I won't go into detail here. But what is important is that I'm not saying that each single element is necessarily illegal or illegitimate here. But I think it is fair to say that in combination, these patterns render freely given consent completely meaningless. Finally, as a last example, let me show you one of the latest innovations of the ad tech industry, which I call legitimate interest patterns. So if you go to the settings layer, you see that consent is deselected by default, as it should be. However, only if you look very closely, you see that there is a further option which concerns legitimate interest. And here you have to manually deselect each purpose. Without prejudice to dark patterns, in my opinion, legitimate interest is in any case no proper legal basis for cookies for several reasons. But at this point, it should suffice to point out that legitimate interest is additionally abused to render the consent legal basis meaningless through the use of dark patterns. Thank you very much.
Thank you, Christian, for this very brief intro, and I think great overview of what problems we're facing. I'd just go on and give the floor to Christiana and to see what she adds from her research to that.
So in this talk, I'm going to present the topic of dark patterns in consent banners. And this is a joint work with the computer scientists, with the data protection lawyer, and with the designer. So we already know that some design choices were considered illegal by the Court of Justice and by regulatory decisions of some DPAs. Why? Because they violate legal requirements for consent. So, for example, unbalanced options and pre-ticked boxes are quite known and already mentioned by Christian. They violate the legal requirement for an ambiguous consent request. And we have identified some dark patterns within these design choices. So let's see the example of the unbalanced options. The use of aesthetic elements like colors, the size of the option, the green color that is used, the position of this option, of accept option compared to reject, makes users prone to accept consent in detriment of other choices. But in our work, we also detected gray design choices. Why gray? Because they are not necessarily violating or are unlawful. There are still no case law from the Court of Justice or any regulatory decision, but they are in friction, they are in tension with the legal requirements for consent. So within a consent wall design choice, there is no access to the website content until users make a choice to accept or to reject. Within a reduced service, if users reject consent to tracking, access to the content will be limited. So instead of 10 articles in a website for news, a user might have 5 or 3 news to read. Within a tracking wall, if users reject consent, you will have access blocked. And of course, this violates the legal requirements for consent and also several data protection principles, especially because consent needs to be accessible according to Article 7, number 2 of the GDPR. A consent request needs to be unnecessarily disruptive to the use of the service, according to Recital 32. And mostly, consent needs to be freely given without detrimental consequences or negative consequences, even if users reject consent. And we have identified a dark pattern here, forced action, because for users to actually have access to the website, they are forced to accept consent. And finally, dark patterns can escalate when they are deployed by consent management platforms that provide banners with dark patterns by default. So this is which are then implemented by websites when requesting consent from end users. This is the example of OneTrust, which is one of the most popular CMPs in Europe, providing banners with dark patterns by default. In this design choice, you see the option Allow All on the top level of the page. So it's the first option that the users see. And so it's quite easily viewed. And we only see the option to reject all purposes. You see all this list of purposes, and the option to confirm the settings only at the bottom of the screen. And we have identified the dark patterns of obstruction because actually the option to reject all is made more difficult that it needs to be done in order to dissuade users to reject, right? There is the dark pattern of a false hierarchy because the option to accept all is here made in the first place. And the sneaking because it attempts to disguise relevant options, reject all, or to select some purposes instead of others. And this is the way wherein CMPs are making dark patterns escalate throughout websites. This is what I wanted to share with you for now. Thank you.
Thank you, Christiania, also for the this great insight and highlighting the role of CMPs. I think that was very interesting. I want to move on to ask you, Mr. Ebel, after probably having, well, not for the first time seen these examples. I think what is interesting for many here is are dark patterns on the list, on the agenda of the Commission, on your personal agenda, and maybe just in broad terms, what might be the most pressing issues that the Commission identifies in that respect?
Well, thanks for first inviting me to the panel. If Marianne wants to go first, I can also wait. No? Okay. Yeah, I think just maybe one comment. When I looked into this issue of dark pattern, which seems to be very much en vogue now, my impression was that I recognized many experiences I have made in the past, also outside the cookies issue. When I booked flights before Corona and hotels and so on, I think I recognized many of the issues which are now described as dark patterns. And I think one general impression is also that I think one has to distinguish between, let's say, illegal practices and what Christiana described as the gray or dark areas, which are not necessarily illegal, but maybe not compatible with the spirit of the law. And some of these practices may fall into the Unfair Commercial Practices Directive, but that's to be seen, and I guess Marianne is much more familiar with that. The reason why we see this very much in the cookie area is probably because cookies are such an important element in the online world, and what we see is the cookie management or the content management pop-up windows, which are needed by the companies to collect consent, because consent still is a very important legal basis for accessing information from the terminal equipment, computer, smartphone, and so on. And we and let's say this is and in any event for tracking of people and personalized advertising, consent seems to be the only way of getting consent. So to your question, I think it is on our agenda as a commission. Whether it's on my personal agenda is probably not relevant here. I think maybe two comments to what was said in the excellent presentations of Christiana and Christian. On the issue of legitimate interest as a legal basis for accessing terminal equipment, I fully agree with you. There is no legal basis in Article 5.3 of the ePrivacy Directive referring to legitimate interest. I'm aware of the kind of fallback solution which was applied in Germany, but I think that is over since the court, the Bundesgerichtshof's judgment at the latest. And I understand that some new legislation is in the making. But legitimate interest, as it is used across Europe, not only on German websites, as it was shown in the presentations, I think there's no legal basis for that as a basis for accessing cookies, accessing information on terminal equipment and storing cookies there. And maybe the last point is an interesting point from the French CNIL, the Commission nationale de l'informatique et des libertés. They have taken a much tougher approach on this issue now, and I think they cover some of the issues which have been described as dark patterns. Namely, they have the kind of dogma to say that refusal of consent must be as easy as granting of consent. And if you apply that, as you have seen in some of the charts, then it becomes obvious that some of those practices are probably not compatible with the current ePrivacy Directive. And I think the CNIL reasoning may be founded on the basis of what is in the GDPR about withdrawal of consent, that withdrawal of consent must be as easy as the giving or the granting of consent. I think if you apply the same reasoning, refusal of consent, so not the kind of ex post withdrawal, but the ex ante refusal, should be as easy as the granting of consent.
Thank you, Mr. Ebel, for I think that very good first take. That I think was a lot in there that we might want to unpack when we move on. Miriam, let me move to you and ask: do you, from your perspective, the consumer perspective, do you have a lot of complaints, and what is on your agenda there when you think of dark patterns? Is it a hot topic for you?
Absolutely. Well, first of all, thank you very much for the invitation. And I must say that we have recently acquired a new member, so we no longer represent 45, but 46 organizations. So I am obliged to say that. Yeah, so definitely the issue of dark patterns, it's on our agenda. I personally also encounter it every day. And I agree very much with Mr. Everell when he was saying that this issue goes way beyond, cookie banners. We see the issue of dark patterns beyond privacy consent mechanisms, which is quite concerning. Probably I know that we will talk about it later. I think what was quite good from the presentation is that it's clear that dark patterns come in different forms, and they can come in the form of visual interferences. We talked about forced actions, also pervasive defaults. The law is clear in certain cases, at least with regards to consent and cookies. What we see generally is that parts of industry have implemented the law in a way that does not really protect consumers. So the issue is not so much about the law right now, in the sense that it should, we should rely on consent, but how parts of industry have implemented the current law. And we see that there's a false sense of control that is given to consumers. I mean, sometimes even if you click reject, there has been research that have shown that cookies are still stored in your device. So in practice, even that those types of banners do not give you the protection that you may infer, even though you may go through the hassle to reject everything you can. So clearly what we need is not only to update the law. Of course, we're now talking about the ePrivacy regulation that is currently being discussed, that hopefully will go even beyond the levels of protection of the current directive. At least we will try from our side, and I know Mr. Ebel will also try from his side. Yeah, we hope that we will see more enforcement. Because it's true that there's some gray areas that hopefully the new ePrivacy regulation will address. For example, the issue of cookie walls, or more generally tracking walls, was mentioned. In Belk's view, we would like tracking walls to be prohibited. And we'll see whether we will manage to get that in the regulation. It's up to legislators to decide, but that is our position, that we don't think that consumers should suffer negative consequences for their choices. And also importantly, something that is very important is to also go beyond just needing to consent. The ideal scenario would be that there's nothing to consent about because you don't deploy pervasive tracking on the consumer. So we would like to encourage the adoption in the legislation of the principles of privacy by design and by default. I think that would greatly contribute to the discussion. And then if I may just finally, just to introduce the topic, because I know we'll discuss about this indeed, dark patterns is also addressed in other pieces of legislation, notably the Unfair Commercial Practices Directive that Mr. Elber referred to before. But we don't think that the current Unfair Commercial Practices Directive it's providing enough protections for consumers. So we're working with other parts of the Commission on how to go forward, and there are other initiatives like the Digital Services Act Also, the AI proposal that has been recently presented by the Commission, where these issues are being discussed, as well as the Digital Markets Act. So luckily for us and for researchers, there's lots to untangle and lots to do to meaningfully protect consumers online. But I stop here for the moment. Thank you.
Thank you also, Miriam, for that. I think also kind of overview that touched on so many of the issues that are relevant here. And I want to move straight back, maybe to ask Mr. Eberl, and looking a bit on the current state of the law. Do you have because also Miriam mentioned that actually the law is kind of maybe not the problem, it's more the enforcement side. Do you think that the current state of the law has in a way worked out as envisioned by the Commission as regarding consent? And is that maybe not the real problem that we're having? You're on mute still.
Sorry, technology. I think, as it has been said by other speakers, I think it's important to see, on the one hand, what is the legal situation and what is the enforcement reality. I think on paper, I think the current situation is quite consumer friendly. I think the consent requirements in the GDPR, which apply also to the ePrivacy Directive, they are quite clear, and they require a clear and unambiguous indication of the agreement by the consumer or by the data subject. They must be freely given, and so on. So the requirements are there. The question is the enforcement. The EDPB, the European Data Protection Board, they have issued guidelines on consent, which is a very important document, because it's important that this is applied in a kind of consistent way across Europe, because especially on the issue of cookie walls, I think we have had guidance in a very diverging ways from different data protection authorities, and it's good that there is some consistency thanks to these guidelines. I think Christiana or Christian mentioned the pre-ticked boxes, which Planet 49 definitely sent away. But it's also already in one of the recitals of the GDPR. Then I think regarding the dark patterns, I think what is in recital 42 of the GDPR is that the data subject must be aware of what it consents to, and I think that's an important element, because I think in the presentations there was this gray area where we are in an area where there is maybe not yet deception, but close to it. And some, I think, misguidance, misleading elements, which may not yet be illegal, but I think it's something which has to be taken into account when a data protection authority or ePrivacy competent authority evaluate whether a practice is compatible with the letter and the spirit of the GDPR. I think also the Article 7.4 contains some elements on plain and clear language. So let's say the elements must not be hidden somehow. I think there was this example with this lady protecting the user. I think this is this kind of different language style and putting something positive and other things negative. I think this is something which has to be taken into account when evaluating whether a practice is compatible.
Maybe, sorry.
Yeah, and maybe a last point again on the, let's say, coming back to rather basic civil law. Under German law, the consent declaration is a declaration of intent. It's a Willenserklärung. And of course, if there is deception, then there is a possibility to resign the agreement or the granting of this declaration. I think that is something which one has also to keep in mind, that there are tools under civil law which can be applied, but as Marianne said, it has to be seen whether the Unfair Commercial Practices Directive plus civil law are sufficient, or whether additional tools are needed. And And as it was said, the colleagues are looking into the Digital Services Act and other instruments.
Maybe that's a good one that we can pass on as a question to our two researchers here. Christiana, do you think that actually the law is good as it is, or do you think it would need more redefining, more clarifications?
So I understand that the legal requirements for consent are very clear. Actually, from 7 high-level requirements that the GDPR provides, we have understood the 22 legal and technical requirements for a consent banner to be valid. But we understand that also data protection principles like minimization, purpose limitation, privacy by design, fairness need to be accounted. But yet they offer some, they are not yet operationalized in order to regulate specificities of design, of user experience, of user interface. For example, do not provide metrics regarding the number of clicks in order for the acceptance to be equal regarding to revoke consent or to withdraw. And or, for example, to regulate issues like aesthetic aspects, like the size or the tone of language aspects, textual features, or the positioning or colors that ought to be used to provide the same level of attention or reception from the user side. And indeed, there are several guidelines provided by DPA, several DPAs, and CNIL is one of them. Today, it made a nice call for this easiness to reject or to withdraw consent. However, even if the privacy by design and by default approach is really welcome, it's hard still to regulate these textual aspects and these UI, user interface aspects. Therefore, CMPs, for example, and several websites are using this regulatory gap to optimize consent, because these user interface aspects, they do optimize enormous consent rates. This is what we have understood. That is why also dark patterns are escalating, because they are taking advantage of this regulatory gap. And these guidelines from DPAs are only guidelines, are not enforceable. So there is not yet enough legal power for this simple decomposition of principles to become operationable in the daily life.
So I understand that mostly all of you are saying that actually the law itself is not the problem. Maybe I briefly want to give the floor to Christian to ask him if he shares that, and also thinks that actually that we should look somewhere else than the legal requirements here.
Thank you, Quirin. I would agree that it is largely an enforcement problem, but I would like to draw the attention to one particular aspect. And I think we have a dilemma here, because the data protection principles sometimes directly contravene the needs and interests of the ad tech industry. And I believe this is some sort of an irreconcilable conflict. So when we look at the principles of privacy by design and by default, they essentially mean that operators should proactively design their services in an effective manner which supports data protection principles, and in particular data minimization, and B, that such principles are applied by default, taking particular into account that many users do not possess the technical skills and knowledge to engage in privacy management. So dark patterns employed in the context of CMPs do the exact opposite, because the entire business model of targeted advertising is based on the principle of data maximization instead of minimization. Dark patterns are user unfriendly by definition, and they do not take informed consent seriously. To the contrary, they work diametrically against it. So in theory, Article 25 of the GDPR should prompt operators not to use dark patterns, or at least prompt data protection authorities and courts to take actions against them. But this is apparently not happening enough in practice. So the reason for this might be that Article 25 of the GDPR might be still too vague in order to be implemented in practice. So here I believe it is actually the legislator's responsibility to amend the substantive rules and give data protection by design and by default a more concrete shape.
Thank you, Christian. I think
just to build on the note of Christian, guidelines need to pass from soft law, general principles, into more granular and operationable criteria, and we could expect something from DPA's decisions, or even from the EDPB level, to provide some sort of more objective criteria to decide on these aspects of UI and the textual features. That would be very important. Let's see what the privacy regulation will bring to us.
One thing that Miriam has raised in the beginning, and I think it's very relevant here, is that we can either keep going down the road of consent and see how we can refine the criteria, or we could just choose to have a little less of consent and a little more of prohibiting certain activities. And one thing I want to ask all of you, and maybe starting with you, Miriam, is would you actually think that it would be better to just ban certain forms of tracking and cookies altogether, or is that not something you would advocate for?
Great question. I would like, before I reply to that question, to get a step back, to respond also to some of the things that have been mentioned before. And the fact is that, of course, I don't want to pass on the message that the current law, it's perfect, and then that's it. We don't need to, worry about how to solve dark patterns. I think if we're having even this seminar, it means that something is not okay beyond enforcement. Of course, we have high hopes on the ePrivacy regulation that hopefully will complement the GDPR in the electronic communications sector, and would also complement the need for protections not only for personal data, but also for privacy as a fundamental right as well. And here, we need to go further and ask for prohibitions. I think that's what the current legislator mood is seeing. Basically, that we see that there's basically more calls for restrictions. I mean, we have recently seen the European Parliament, for example, asking for a ban on certain forms of targeted advertising, particularly micro-targeted advertising. In BEUC's view, we think that those options should be considered. Now this is being presented as part of the DSA, the Digital Services Act, which only at the moment focuses on transparency. I think we all know, and I hope you all agree, that we're not going to solve everything with just transparency. So we indeed advocate for stricter rules. And what we at least want to hope from legislators is that they will have clear prohibitions with regards to tracking and profiling towards consumers below the age of 18. Because we see that, if there's no political willingness to go beyond for consumers of all ages, at least something should be done for minors, at least, please. So we would like to see basically a development in the legislation to go towards greater restrictions and not just rely on the current legislation. I think each legislation should complement each other. It doesn't mean that consent should not be the legal basis. We actually believe that even in the electronic communication sector, the consent should be basically the cornerstone requirement for processing and the use of electronic communications data. So that would not change. It's just that we need further protections. And it is true that it's difficult to enforce key principles that already exist in the GDPR, like data minimization, data protection by design and by default. But again, we need enforcement, and we need to maybe focus on best practices of good businesses that are trying to include privacy and data protection as part of the core business. Because at the moment, what we see is that consumers are deceived by design, and we want to have protection by design and by default. Yeah, that's what I can say at the moment.
Maybe that is a good point to also ask Mr. Eberl on the current Trilogue, and how if there's any actual move to restrict maybe some form of tracking, third-party tracking, let's say tracking of minors, by law in the current Trilogue, or is it not going that way, and we're gonna have still consent in all these instances? You're on mute still.
I think, well, it gives me some time to reflect on the question. I think, let's say, going a step back, I think the GDPR and the whole data protection regime is somehow based on consent as one of the key elements, and the ePrivacy Directive even more, because for many issues consent is the only or the principal legal ground for processing. That changes a bit in the ePrivacy regulation, especially in the council text. But of course, there's a derogation from consent that is rather to allow processing without consent. So for specific purposes, which will have to be seen what Parliament will accept and where compromises can be found. So I think the concept of consent, as we have seen in the previous round, I think is something which seems to work on in the legal text. The question is the enforcement. I think neither the GDPR nor the ePrivacy Directive or the proposal for the regulation foresee kind of banning of certain practices. I think that is probably not the role of data protection law. I think the requirements are quite high for consent and also for other legal grounds. The question is also whether this, if we have dark patterns, why a ban on dark patterns should only be for the online world, for the privacy regulation, and not for other consumer relevant issues. And as it was explained by Marianne, the DSA proposal doesn't contain a ban on personalized advertising. There are calls from some committees in the Parliament. I don't know whether this is a majority view, but there are calls in any event, and they have to be taken serious. And there are many findings by competition authorities, by data protection authorities, that some things in the current way the online advertising ecosystem works are probably not compatible either with competition law or with data protection law. I think these issues have to be fixed. Coming to the issue or the question, what can be done by the ePrivacy regulation, I think there's one provision in the ePrivacy regulation which is somehow about the maybe the modalities of consent. It's the Commission's proposal of Article 10, which is about the settings, the advanced settings in the browser, whether a user rejects cookies altogether. That proposal has been taken up by the Parliament, which has a kind of by default setting with a strict application of privacy by design and by default, which the Council doesn't like at all. The Council has deleted the whole article. So here we have a quite opposed positions, but we should also keep in mind that, let's say, the market develops in a certain direction, because Firefox and Safari already have the default settings as the Parliament suggests. Google has announced to introduce it for whatever reasons, and not necessarily only privacy related reasons. And then there's Microsoft left, because the other browsers, they are rather, as I understand, rather pro-privacy than privacy invasive. So the question may be a legal question, but it may also be overtaken somehow by market development in a couple of years. And I think one issue which can be solved in this Article 10, but this depends, of course, on the co-legislators, and none of them has, by the way, foreseen any ban on certain advertising practices in the ePrivacy text. One could think about including some of the elements which Christian mentioned, on somehow giving some concrete or some meat to the bones of privacy by design and by default of Article 25 GDPR, if there is a willingness by Parliament and Council to address the issue of this whole cookie fatigue. Because it's not only the way how people may be induced to give consent, but I think one concern from a Commission perspective is also the mere flood of cookie pop-up windows. And I think one has to find a balanced approach, which on the one hand allows companies to ask for the consent, but in a way which does not use these kind of dark patterns, and in a way which allows the user also, in line with what CNIL seems to enforce now, that it's as easy to reject as it's to accept. And then so that there's a legitimate call by the companies that they can collect consent, but this should be done in a way which does not annoy the users, and something like clicking away the cookies with one click, or accepting with one click, so this kind of equal distance, that could be something which could be acceptable. But I think this is something where the Commission can only be a kind of honest broker between Parliament and Council in order to facilitate compromises. But if there's request for that, we are open to help.
I think the proposals by the Commission, but also the Parliament and even the Council, maybe have showed actually that there's a certain feeling of uncomfortableness towards the situation today. And you have just mentioned examples, I think, for that express that in the current proposals, although the Council deleted Article 10. I wanted to ask maybe Christiane and Christian, starting maybe with Christian, do you think that actually these current proposals would already make the situation a bit better for the users? Do you think it's going into the right direction? And maybe which one do you think is the most relevant one that you might want to keep?
Thank you, Quirin. I believe there are indeed already some elements which could tackle dark patterns if properly implemented. However, I note that the different proposals, as already mentioned, vary significantly. Unfortunately, the proposal by the Council basically removed all of these elements and could even lead to an increase of dark patterns, in my opinion. The most important element has already been mentioned, and this is the centralization of the consent management in the browser, which the Commission proposed in Articles 9 and 10 of the draft regulation. And the Parliament actually picked up on that and added that this global consent given in the browser should be implemented through a legally binding signal. So here we actually see, in fact, an implementation of the privacy by design principle. And the Council, on the other hand, completely watered down the centralized management proposals and suggested that individual consent should prevail over the global browser consent. So this is basically an invitation to continue the use of cookie banners and use dark patterns as a tool to override the centralized consent option saved in the browser. So regarding this issue, I strongly support the Parliament's proposal. Also, the Parliament added that privacy protective settings should be activated by default. The Commission, on the other hand, only suggests that the user must consent to some sort of a setting after installing the browser, but does not impose privacy by default. but in both proposals, there is actually no safeguard included which prevents the browser manufacturer itself from using dark patterns. So I think this is something we should keep in mind. Even if we can get rid of all of the cookie banners, there is still no guarantee that dark patterns would not be employed within the browser settings themselves. So it would be good to consider that as well. And finally, one last element which I found is also from the Parliament's proposal. This is draft Article 8, paragraph 1a, which seems to be a prohibition of cookie walls that make the access of the website conditional on tracking. So this is, in fact, a concrete proposal which would prohibit some sort of forced action patterns.
Christiania, do you think that's a good way to go, putting all eggs in one basket, so to speak, centralizing content management and then hoping that at that point there will be no dark patterns? Do you think that's a good way?
So the current Article 4a of version of February of this year, it mentions that consent could be expressed, may be expressed by using these appropriated technical settings of a software. Well, this narrative is quite vague and a bit ambiguous, and I think that Article 4a, to actually eradicate consent fatigue, should oblige browsers and operating systems. So to become to enable such a possibility to become enforceable, binding, and also, besides being binding, also user-friendly and an effective mechanism to allow controllers to obtain consent and to create then a level playing field between all actors. And building on what Christian says regarding tracking walls, as of today, according to, I believe it is Article, I think it is, let me consult now the legislation, is Article, well, whatever. Let me see here. It permits an option between a paid and free of tracking access to websites or a free tracking website access. So I believe that users should not be tracked by default, especially for advertising purposes, which is what the current version of the draft of the privacy regulation permits. So to be tracked by ad-funded services for tracking purposes, especially by third parties, and especially when users are dependent and need to access services. And so I think that the current situation needs to be reviewed on this article about permitting tracking walls.
Miriam has already, I think, mentioned that basically before that. I think you consider that very important. Do you have a take on what is like for you the most of the articles on the provisions on the table? What do you think will be the most important one to have?
Absolutely. I mean, and also to respond to your previous question to Christina, we would not put it all in one basket. We need all the elements to work, right? Even if we keep consent as a cornerstone requirement for the processing of electronic communications data, we need to also fix what is not currently fixed in Articles 8 and 10. For example, so just to summarize, for us, our 3 priorities is first to ensure that Article 6 keeps consent as the main legal basis. We would not like to see processing based on a legitimate interest or further processing for compatible purposes. Of course, we are aware of proposals in the Council. We are also aware of the good text of the Parliament, so we hope that it can be balanced out. On Article 8, we also want to introduce a ban on tracking walls, and here the Parliament's position is the closest to our position. We don't think that consumers should just get refused a service or a functionality just because he or she wants to exercise the their fundamental right to privacy. At the end of the day, we're talking about a fundamental right that is not subject to negotiation. The businesses should adapt to this fundamental right and not the other way around. And then finally, our third priority really is to get Article 10 right. We don't, of course, agree with the Council to delete it. Quite the opposite. We would like to ensure privacy by default and by design, as I mentioned before. We would like to see the settings in hardware, but also software, to be set in the highest level possible of protection for consumers, and that's the way forward. I think what we need is a clear change in the mentality of businesses, or the majority of the business. I mean, as we describe it, because AdTech was mentioned before, recently our members have contributed to the debate with a report and also an action on AdTech. The Norwegian Consumer Council, together with several other REOG members, issued a complaint and a report called Out of Control. We think that the current AdTech system, it's out of control. So basically we need to improve the current rules, but also enforce the current ones. And on top of these, of course, as mentioned before, the privacy regulation is just one piece of the puzzle. Unfortunately, in law, we don't solve everything with just one piece of legislation. We need to think broader, and also we would probably need to look at how to improve the unfair commercial practices directive, because it's more horizontal and it goes beyond privacy or the electronic communication sector, which is the case of the ePrivacy regulation. So yeah, these are our three top priorities that if we get them, consumers will be better off. But if not, at least the minimum requirement is to ensure that the current level of protection afforded under the ePrivacy directive and the GDPR would not be undermined by the new regulation. I think this is paramount, and this is very, 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 very important.
Do you think the centralization of consent is worth fighting for? Marianne?
I think so. Basically, they need to coexist, right? You should have your settings, and of course, there we would need to pay attention in practice as to how the industry would implement them in practice, because you may well have a setting, but if you're not prompt to take the most privacy-friendly option, that's not going to solve your problem. And another thing, in case of having technical signals being sent, it doesn't mean that no tracking will happen. So we need, as I said, the three key articles of the privacy regulation, Articles 6, 8, and 10, to be strong. That's our position. We understand that the Council took a different view. Luckily, some member states are more favorable towards the position of the Parliament. And also the Commission text is not bad either. So we have some hope that we can make it work, but we should not just rely on Article 10 as the solution of all the problems, in our view.
Maybe we can briefly...
I just wanted to add something. On the current version of the privacy regulation draft, the issue of cookie walls and paywalls are referred to. So this provision, this possibility to have a paid for service without third-party trackers, or to have this free service where consent to the use of tracking is not conditional. And this is mentioned in the two recitals. So if the privacy regulation is to harmonize current practices, some ban or some legal certainty regarding tracking walls needs to be provided at core legal prescriptions, not at recital level. I just wanted to add this element, because today we will see even more the issues of tracking walls versus paywalls for users to subscribe a service and to pay a service in order to have access and not being tracked. And it's at recital level, will not actually harmonize it within current member states.
I want to really ask Mr. Ebal again if he thinks that, like, how he senses the current discussions. Is the council likely to prevail, or do the parliament's proposals on 6, 8, and 10 have a chance to stand. And I guess we probably also wanted to answer the cookie wall question, maybe.
Yeah, maybe first coming back to the issue of the let's say putting all eggs into the hands of the browsers, I would be very reluctant to do that, because if you look which companies are behind some of those browsers, not sure you would that they have no conflict of interest. On the cookie walls, what Christiana mentioned is the text of the council. Of course, the parliament's text is what was mentioned before, this Article 8(1)(a) on ban of cookie walls. And I think that one of the challenges in the negotiations will be to find a suitable or balanced compromise between the two approaches. I think on the one hand, we have been discussed today a lot about the protection of the end users or the consumers, about hopefully confining or getting rid of these cookie pop-ups and cookie fatigue. On the other hand, I think we must also be aware that it is also hard to argue that a company must be allowed to, or must be obliged to, give away its content for free, because I think that will also have an impact on the quality of the services available on the internet. Whether this should be via cookie walls, that is a different question, and I think that is something to be discussed with the co-legislators. But I think we must be aware that somehow these services must get some financing. Whether this is via personalized advertising is another question. I think this is something we, as society and also at the legislative level, have to decide and have to find a common understanding. But I think some kind of advertising is needed to finance these services and the quality of these services. And if it's not financed by advertising, it will have to be paywalls. And pure paywalls, I think they're not illegal. So if the service says, I offer you can only get my service if you pay for it, and there's no alternative, even no advertising finance, that is completely illegal. That's most of the streaming services are such kind of services. So I think we must be aware what we want. I think a solution should be a kind of privacy-friendly advertising financing, and then one should see how certain practices should be banned, whether they will be banned by the ePrivacy regulation, whether they will be banned by DSA, by UPC, or other provisions, or by competition law intervention. That has to be seen. But I think we cannot just say we oblige companies to give their content away for free without any possibility for financing.
Maybe after we have, I think, went to speak a bit off from the dark patterns perspective, I wanted to focus it a bit more narrowly now again, because I think that is the question of cookie wall or not, and do we accept what modes of payment in a way do we accept for content, is distinct from the question how do we let people decide, if we let them decide or if we make them decide, and also the question of like letting it be a centralized browser setting or individual website setting is also again a different one from how do people decide and do people get nudged in a certain way into making one decision or the other. So I wanted to go back to that and maybe have one last round and encourage also everyone to ask questions in the question sections for our last 15 minutes. I want to go back to that very topic of dark pattern and like nudging decisions and ask if maybe we should take up provisions to address that very specific topic in the ePrivacy regulation. Like we've already said, like there's a lot in consent, there's a lot there, but is it not time to actually address it specifically and maybe take up a specific provision? You have suggested, for example, a sort of equality principle or something like that. And I guess I wanted to ask maybe sort of Ms. Christian, from his research perspective, if he thinks there should be something specific and maybe even go so far as to propose how something like that could look like.
Thank you, Quirin. I think there are indeed some concrete measures that could be implemented. However, unfortunately, I believe most of it still revolves around the consent provisions, and the consent provisions are included in the GDPR. So I believe the most effective ways to regulate dark patterns is actually to amend the GDPR. And I know this is probably politically very delicate and difficult, but I would be also interested to hear from Mr. Ebel if this is actually possible to amend the GDPR in the course of the ePrivacy regulation. But there, to make it a bit more concrete, there are different solutions how this could be done. So one very straightforward solution could be an addition along the lines of the California Privacy Rights Act, which states that an agreement obtained through use of dark patterns does not constitute consent. I am, however, not sure if it is really the best way to directly include the term dark patterns, since that term itself is quite ambiguous and would have to be further defined, but there are alternative means. Another option would be to add that freely given consent within the meaning of the GDPR must not be obtained through the exploitation of behavioral heuristics or biases. And finally, there is a third option I tend to prefer, which would directly address the design elements of the CMPs and thus effectively implement privacy by design. So one could add a sentence in the consent provision which reads, if consent is obtained through buttons or other interface design elements, there must be a corresponding option to reject consent, which must be entirely equivalent in design, in particular in visibility and accessibility. And I think this picks up a bit on that what Mr. Eberl mentioned, that we can actually we should encourage methods to make privacy by design more concretely, or to put a bit more meat to the bones. And I think that would be one way to go that would ensure that refusing consent is just as easy as accepting consent.
Maybe we can collect from Christiana also, Christiana, her maybe suggestions for what is there something that should be done at this point that could be added to alleviate the problem of dark patterns?
So I think that the CMPs and several other consent management providers use and abuse of dark patterns or any sort of manipulative practices, and it because they work, and so they will continue to exploit such regulatory gap. And I think that some regulatory action, some operative criteria, objectives can be incorporated at legislative level, and this is the point. This is the moment. Otherwise, they will continue. Companies, organizations in general, will make use of manipulative and deceptive practices. So, for example, taking into the lessons learned from the Unfair Commercial Practices Directive, why not to apply a blacklist and then a gray list of manipulative design online practices, not only applied to UI, to the interface, but also to textual elements. So, and there's some objective criteria for operators, for decision makers, for DPAs to actually apply uniformly such objective criteria. What is adequately informed? What is an alternative service? What is an equivalent service? What is deception or manipulation? What are the ingredients for it? So some objective criteria to discern what is an illegal dark pattern, manipulative dark pattern, from gray zones that we have detected and that actually provide a lot of friction and tension with the legal requirements for consent and also for data protection principles, they need to be indeed incorporated at legislative level. So not only at the guideline level, but within the scope of the incoming ePrivacy regulation. Otherwise, the current practice will remain.
Marianne, could you buy into these suggestions, like this privacy by design equivalent provision, something regarding CMPs or a UCPD blacklist?
Look, I mean, first of all, I want to make clear that we are not advocating to review the GDPR, at least not yet. We think it's a bit too early, even though we are the first ones to spot that it's not a perfect text. But you also need to understand that it was very, very difficult and to achieve the text that we have now. And at least when it comes to the requirements of consent, they're good. It's just that they are not being implemented and they're not, the enforcement is not there yet. Particularly when we talk about cross-border enforcement, which is a subject we have not discussed yet. So that's the first point. We need to have more enforcement to test the limits of the current law to be able to identify the gaps. I mean, if you think about the ruling that was mentioned before, the Planet 49 ruling, this was a case that originated actually because a member of ours, the German Federation of Consumer Associations, VCVV, launched the case. So if there are more cases like this, we can, have clear guidance from the court. We see the value of guidance from the EDPB, to be honest with you, because they're very important to ensure a consistent implementation of the GDPR and clarify elements that the legislator will not do. I mean, I worked on many different laws, and I can assure you details is not something that legislation would do, also because the legislation needs to be future-proof, right? So you cannot possibly imagine all of the things that companies will do to implement the law. So I think it's important to be flexible enough and not to be too prescriptive. Having said that, we think that the place to look at really will be the UCPD, the Unfair Commercial Practices Directive. Because here we see that I think there's a broad consensus in academia that are specialized on consumer law that it's not enough to prohibit all types of dark patterns. I think that is quite clear. And I know that the Commission is looking into this, Justice is looking into this. So we hope to contribute on how to improve the situation via there. And of course, the ePrivacy regulation is the lever. So of course, if there are issues, that could be addressed, I think the recitals can be clearer with regards to, not allowing what we see already now in terms of dark patterns. I think I agree that we cannot hope that, self-regulation will solve it, because we have seen that it has not delivered. So I agree on that part, that the privacy regulation needs to deliver to end the current issues we're seeing. Otherwise, it would be a missed opportunity.
I guess that goes then to Mr. Ebel, and the question is, do we see a chance there to maybe not change GDPR, but maybe to take up something in the ePrivacy regulation that in the end is something like that, because we might change a bit the consent provision for ePrivacy purposes. I think basically the current proposals do, so it doesn't seem completely unthinkable.
On the GDPR question, I think we have heard the Justice Commissioner, Mr. Reinders, yesterday or this week saying he's not in favor of opening it. We have heard the former Justice Commissioner saying it should be opened, but that is for other purposes, namely the ones explained by Marianne on enforcement and one-stop shop. And I think last year the Commission's report on evaluation of the GDPR also concluded that it's too early to open. And I think if there are issues to be fixed, it's probably not the consent provisions, but it's other provisions. But that, I think I fully agree with Mr. Reinders that it's too early to open that. That being said, I think what is one of the key elements of the ePrivacy regulation is that it relies on the definitions of the GDPR. And I think it would not be useful rather very much confusing for citizens if there were different consent concepts in the GDPR and in the ePrivacy regulation. I think nudging on the consent definition, for me, this is a no-go in the ePrivacy regulation. And I think that has also an impact on what is possible regarding cookie walls. I think the GDPR does not categorically exclude certain quid pro quo for consent. So it does not say cookie walls, or let's say, cookie walls are to be banned. I think Parliament goes beyond what the GDPR said, but that is Parliament's right, of course, to change legislation and to create something in the legislature. But the window for flexibility regarding this is relatively small in the GDPR. But what we want is that there is full consistency of the ePrivacy regulation with the GDPR, in particular as regards consent. So we don't want to change the consent requirements. I think some of the elements Christian mentioned could be implemented. One can take inspiration also from the CCPA. But of course, the ePrivacy regulation will never be as detailed as this regulation of the I don't know, the commissioner in California, which implements certain provisions on these dark patterns. But I think one can take some general principles from that. I think on this kind of that it must be as easy as granting as refusing, that I don't know whether one has to say that the icons must be as large as possible, but I think one can find some general wording which says that that there must be kind of, it must be, it comes back to this principle that it must be as easy to go both ways. And I think one element, if it is as easy to reject as to accept, I think that may also have a positive impact or an incentive on the provider's data protection statements or cookie declarations. Because if people are not just frustrated and click, yes, I accept everything, but if they can as easily reject, then there is maybe an incentive for providers to obtain or to gain the consent of the users in convincing them that their service is valuable. They cooperate only with a limited number of partners, which have good renommee or reputation for treating or for dealing well with data, and they may get then some consent or some granular consent as it is possible to set it now for certain purposes. But I think it may have an impact also on the complexity and length of these consent declarations, because as you said, it was said in the introductory statement and in the presentations, that one of the elements is also just to frustrate the user who doesn't want to read 10 or 20 pages of consent declaration.
And do you feel that at that late stage, maybe just to add, there is the room to include something like that still, and that there's maybe even a sort of understanding already on that?
Well, the basic principle is that the Parliament and Council have their texts adopted, and now it's for them to find compromises. I think there are two chances to achieve something on this issue. The first is the fact that they are far from each other. I think that gives ground for creative solutions, because the pure middle ground between, for instance, no default settings and default settings rejecting cookies, well, I don't know what's the middle ground for that. So I think they have to think about creative solutions. And I think both institutions are, or both co-legislators and all three institutions are very, very much aware of the challenge to find something which, on the one hand, protects end users and their privacy and prevents this kind of personalized tracking, and on the other hand, allowing a way to also for websites and publishers to get some reasonable financing for their services. I think everybody's aware of that, and I think Council has also included some issues on whitelists, for instance, for certain providers. I think there are some ideas already hidden or included in the text of Parliament and Council, and it is now for them and for us to find some magic solution to make them happy and also to make the users and the publishers happy. And the other element is that there are several controversial issues in the whole text, and there will be compromises across articles, or there will be some give and take, and I think that can also help to. That's a risk on the one hand, but it's also a chance to find some balanced compromises.
I think that was a quite positive answer towards that, I might feel. I think we have a very active discussion in the chat here. I'm super happy about that, I have to say. And I think people have provided really a lot of insight and shared a lot of things here. I unfortunately was not able to read all of that at the same time and was looking a bit at the questions section to find out what are the things that we could particularly take up from the chat. I think there's particularly one question here by Ailo Ravna that I think goes back a bit to the very beginning of it, but it might be really the one important point also that one has to take a stand on, and that is a question that reads as follows: Do panelists think that it is possible for consumers to make informed, rational choice regarding tracking cookies? And maybe it's interesting to collect a brief answer from everyone if that is actually an assumption that we should be working on. You're on mute, and I think you can just unmute yourself if you wanna jump in.
Me? Yeah, I really like this question. Very sadly, I would think that informed consent is, as of yet, an illusion in the context of cookies. There are just too many shortcomings, and only some of them are actually related to dark patterns. First of all, the way online targeting and cookies function is not comprehensible to the great majority of internet users at all. It is known that hardly anyone, as Mr. Eberl mentioned, actually reads privacy notices. And it is also studied that it actually requires a university degree to actually understand them. There are studies which have found that the most common reasons why people even accept cookie consent buttons is because they are simply annoyed and want to get rid of them, or they believe they might otherwise not be able to access the website. And then there's a large group of people who simply don't care what is happening with their data at all. And finally, there's another study which indicates that 80% of internet users, in fact, do not want to be tracked at all. So even if informed consent would one day be a reality and could be realized in a meaningful way, only 20% of internet users at maximum would actually give such consent at the end of the day. So in my view, it is very questionable if the tracking business model would be even profitable at all, with only 20% of internet users participating. And that leads me actually to Mr. Eber's statement when he stated that we should allow some sort of income source for internet service providers. And of course, this is true. I mean, no one can expect that they will give away their services for free. But I think it is very important to differentiate between advertising, which is happening for hundreds of years in our society, and I think most people are perfectly fine with that, and on the other hand, with targeted and personalized advertising. And I think this is the dividing line we have to draw, and what we have to focus on.
I want to give the others also the option to maybe comment on that, and I think it leads us into also concluding today's panel. So is it Miriam, for you, the idea of that something that you want to stick to?
No, it's a very good question because it basically prompts the idea that we need to go beyond and have stricter measures for certain forms of pervasive tracking and profiling, certainly. And that's why it's encouraging to see that legislators want to I mean, at least some legislators want to go into that direction. I mean, at the end of the day, the results of research, as Christian mentioned, are very clear. Well, first, consumers often do not understand what they're being presented to do. I mean, I often get screenshots by family members of mine asking me, what do I do? So I think normal consumers do not really understand what they should do, even if companies would claim that it's explained in plain English. So I think having the principle that Peter was mentioning before, that if it's as easy to accept to refuse, we will be better off. But we should also investigate in ways to have stricter rules, perhaps hopefully in the privacy regulation, but other pertinent legislation as well. I think what is very important is that we cannot put all the burden on the consumer to decide. We need protections by default and by design, and that's why I mentioned before that we should not only look at Article 6 of the privacy regulation, but other important articles as well, and also other legislation like the Unfair Commercial Practice Directive, because that has an influence on how businesses interact. And then finally, I want to say that it is not a matter of not financing businesses. It is of course legitimate to have some retribution, but it's about what kind of business model we should have in our society, in our economy. I think that is the key question. It's not about if, but how. And that's what we hope to resolve in the current legislation and future conversations. Thank you.
Thank you, Christiana.
Can I add a note? So regarding still if the current draft accepts cookie walls or paywalls, of course the web publishers need to have sustainable businesses. However, some parameters need to be defined. So, for example, today the current draft proposes a blacklist prohibiting cookie walls for services that do not provide a genuine choice. But still, we need to the recitals or the privacy legal dispositives need to provide some more refined criterion on what is a service that is public or semi-public. Is login or registration needed? Which special categories of data would be allowed? So it's important to define what type of data could be processed, for how long, so the retention periods, define which purposes to avoid this balance. So I think that there's a lot of space and momentum for the privacy regulation to actually cover these aspects and discern in a more concrete scenario, of course, being still future-proof, but discern these gray undefined issues. This is what I wanted to add.
Thank you. And I think we have definitely time and want to hear from you, Mr. Eberl, also on the question of rational choice. And I might want to add maybe an insight from behavioral research. One could say that the GDPR itself, actually by banning pre-ticked boxes, accepts that people are not actually rational choice makers, because otherwise that wouldn't matter so much. So is it for you something that we should stick to, that idea, or moving forward having to accept that people are not as rational and frame our regulations around that?
Well, on the last question, on the pre-ticked boxes, I'm not sure it is against making the users or the end users capacity to make informed choices, because it is not in the middle ground between yes and no. It is already closer to yes, and therefore I think it is not a level playing field between yes and no, and therefore I think it is blocked. On the question by Ailo Ravna, whether informed rational choices regarding tracking cookies can be made, I guess it has been said by several speakers already that I think it is theoretically possible, but I think first it requires a lot of information to be provided by the provider. If they list all the companies with whom they share the data, this may be a very long list, and then all the purposes for which this is used, they probably don't even know. Also, they should know if you look at recent jurisprudence on how the consent has to be collected and how the processor controller relationship should be designed. So I think it is theoretically possible, but in practice it is ununderstandable probably for the user. So this kind of consent declaration, and therefore I think that brings me to what seems to be some kind of consensus that we have to think about what kind of advertising ecosystem we would like to have as society and economy. A last point maybe on solving all the problems with the ePrivacy regulation. I think to moderate some expectations, I think it is important to deal with general consumer protection issues in other pieces of legislation. And we also have to be aware that most of the online advertising ecosystem is outside the ePrivacy regulation. The ePrivacy regulation is the starting point. When the data is taken from the computer, smartphone, or whatever, well, in the future also the voice virtual assistants, connected cars, and so on. So it goes beyond consumer technology or devices. But once it is taken from there, it is under the regime of GDPR. And of course, this is something which has to be solved also within the GDPR. And then I think we are back at the starting point of enforcement of the GDPR. So we can facilitate and address certain issues within the ePrivacy regulation if there is willingness by the co-legislator. But I think many issues remain within the GDPR and they cannot be solved within the ePrivacy regulation.
Thank you so much. And we have hit 18:01, so it's time for us to end today's session. I want to again thank you very, very much for taking the time to being here today with us. I think it was a very interesting conversation. We've learned a lot about the complexities, views, and possible solutions. I think we're all looking forward to how the Trilogue goes, and if today's mentioned solutions might be taken up to some extent, and so that in the future maybe dark parents are a thing of the past. Thank you for shining a light today with us on the issue, and we hope you enjoyed the conversation as much as I certainly did. Thank you and have a nice evening. Bye-bye.